Good afternoon, and thanks for joining Washington, D.C.-based Jennifer Schaus & Associates and our Get FAR Cited in 2020 complimentary webinar series. As you know, the FAR, or Federal Acquisition Regulations, is the rulebook that the federal government must follow when making purchases. Our webinar series pulls from contracting experts to explain each part of the FAR. It is complimentary and recorded. We will post all of the recordings on our website and YouTube channel, where we have over 400 government contracting webinars available for download. A special thanks to our webinar partner in this series, the National Veterans Small Business Coalition Education Foundation. Please visit their website to learn more about the organization. We would also like to thank our friends at Open the FAR for their sponsorship. If your organization is interested in sponsoring the series or one part, please contact hello@jenniferschaus.com. And now a little bit about us. We work with primarily large businesses to help them navigate the federal marketplace. We work with both product and service companies as well as software firms. Our clients span the globe and include publicly traded organizations in a variety of sectors. We provide market analysis reports, contract administration, contract vehicle assistance, and more. All of our services can also be built into a training course for your team. Learn more about us on our website. And we would like to let you know about some ways to reach government and government contractors through us. We offer advertising and sponsorship opportunities through our weekly newsletter and also in our webinar series. For pricing or to place an order, please email us at hello@jenniferschaus.com. And as noted, we now have over 400 webinars in our archives. As we continue to educate federal contractors, I would like to bring to your attention to our webinar series for 2021. The full schedule and speakers are all confirmed. First up is a monthly series called the GovCon Live Q&A Cafe. This is a live webinar series held each month. These will take place on the second Friday of each month in 2021 at 12 p.m. Eastern. We have assembled a group of 4 panelists who are subject matter experts in a specific federal contracting topic. The panelists will make a short presentation about the topics listed here on your screen and then take your live questions about that topic. So for example, January will kick off with our panelists covering CMMC on Friday, January 8th. Our panelists include attorneys, consultants, and other industry professionals. You can sign up on our website under the Q&A Cafe tab. Sponsorships are available. Please email hello@jenniferschaus.com for a media kit and pricing details. In our second webinar series of 2021, we will be covering each part of the DFARS, or Defense Federal Acquisition Regulations. Similar to our current FAR series, this will be a weekly series dedicated to defense contracting, its rules and regulations. This series is complimentary and will be held on Wednesdays at 12 p.m. Eastern. We will run through the parts sequentially, which means that we will start the year with DFARS Part 201 and finish with Part 252 at the end of the year. You can sign up on our website under the DFAR tab. And again, sponsorships are available. Please email hello@jenniferschaus.com for a media kit and pricing details. Now let's move on to learn about today's speaker, Jason Workmaster. He will be filling in for Alex today. You can find Alex's contact information here. And today we are covering FAR Part 50 with Jason. Thank you for joining us, and the floor is now yours.
Thank you very much. Appreciate the opportunity. And if you have questions as we go through the material today, please don't hesitate to use the function to let me know if you have questions. I am filling in for my good friend and colleague, Alex Surya, who was fortunate enough to welcome a new little one yesterday. So it's a good reason that he isn't here today with us to talk about extraordinary contractual actions and the Safety Act, FAR Part 50. Just a little bit about myself. My name is Jason Workmaster. I'm a government contracts attorney with Miller and Chevalier. I have been working in this area for about the last 20 years. I've represented many different contractors throughout the procurement life cycle, from review of the RFP to the bid protest, to compliance issues, to disputes with the government, fraud actions. All of that, all those kinds of issues. And a lot of that work is involved helping contractors who do dangerous stuff for the government and in some dangerous environments. A lot of my work is involved issues that arose out of the Iraq War, and we'll touch on some of that as we go through today. And I do encourage you, if you have not previously looked at FAR Part 50. It's one of the shorter parts of the FAR in my copy. It's just about 13 pages long. It's a helpful thing just to skim your eyes over it. Sometime we're going to hit on the highlights of FAR Part 50 as we go through. And if we could go ahead, please. And you see there is a if we go back one slide, there is a link here that'll take you to a copy, an electronic copy of this part of the FAR for reference down the road. All right, if we go to the next slide, please. All right, so there are two subparts to FAR Part 50. And as you're walking through the FAR, the Part 49 would have been covers terminations, which kind of reaches, you get to the end of a contract. Now we get into FAR Part 50. Again, as I mentioned, one of the shorter parts of the FAR. Now that the FAR has covered kind of everything that can, normally happen in a government contract, we're to some extraordinary things that can happen in a government contract. And it's divided into two subparts. One, subpart 50.1 covers extraordinary contractual actions. These are policies and procedures for entering into, amending, or modifying contracts in order to facilitate the national defense under the extraordinary emergency authority granted by Public Law 85-804. All right, so this is, this relates to extraordinary, this relates to national defense, dangerous things that you may be doing in support of the government. That's subpart 50.1, and allows the government to grant you extraordinary relief if you're in that kind of contracting situation. Subpart 50.2 addresses the Safety Act. Now, if I could get at my time machine and go back to when I first started in this business, the Safety Act did not exist. The Safety Act, so for subpart 50.2, 20 years ago, we didn't have it. The Safety Act implements, the subpart 50.2 implements Safety Act liability to promote development and use of anti-terrorism technologies. The Safety Act was passed shortly after, and we'll cover this in a little bit more detail as we go through the materials, was passed shortly after 9/11, the attack on the World Trade Center, and the impetus for it was, in light of this, this terrible terrorism event in our country, the government was anxious to encourage the development of additional anti-terrorism technology for use by the government, and at the same time recognizing that if you a lot of folks thinking about perhaps getting into that business of developing and making anti-terrorism technology, a concern would be, all right, well, I do this, and my technology is purchased, it fails for some reason, it doesn't, there's a terrorist event and people are hurt, and then they sue me as the maker of anti-terrorism technology. The government had a concern, recognizing that possibility. How do we incentivize folks to make this technology that we as a society agree is important? That's what the Safety Act's about. We'll talk about that after we cover extraordinary contractual actions. So if we could go to the next slide, please. All right, again, so we're talking about subpart 50.1, extraordinary contract actions. The Public Law 85-804, this has been in the statute books for a long time. This statute empowers the president to authorize agencies to enter into, amend, and modify contracts without regard to other provisions of the law related to making, performing, amending, or modifying contracts when the president considers that such action would facilitate the national defense. And agencies with this kind of authority, this 85-804 authority, include the Department of Defense, DoD, Army, Navy, Air Force, there's no surprises there, Department of Homeland Security, DHS, NASA, and GSA. The policy is captured in FAR 50.101-2. This authority may not, I'm sure this will come as a surprise to no one, but it may not be used in a manner that encourages carelessness or laxity on the part of persons engaged in the defense effort, or be relied upon when other adequate legal authority exists within the agency. So this authority is designed, aimed at situations where under the normal rules, under the normal laws that govern government contracting and the normal regulations, the government, normally would not have authority to, grant a contractor relief. This is, to be used kind of as a last resort. This kind of authority. So if you're in a more of a typical situation, if you have a cost overrun, for example, this where this often comes up, you have a cost overrun in performing a contract, and if you have, you have in the contract, you have your standard changes clause. If you have an argument, a valid argument that the government, directed a change, and that under the changes clause in your contract, you're entitled to additional compensation. Well, of course, in that context, there would be other adequate legal authority to grant you relief. And so it's really when you're outside of that kind of a context that this reliance on 85804 would come into play. So if we could go to the next slide, please. And so what are these extraordinary contract actions? They do authorize the establishment of contract adjustment boards that have the authority to approve, authorize, direct appropriate action under this part of the subpart of the FAR and to make appropriate determinations and findings. So within each of the agencies, you'd have a board that would make determinations on, are you entitled to this extraordinary relief? There are some limitations on this authority, and if you're following along in your FAR, 102-3 talks about these limitations. 50.102-3 talks about the limitations. The limitations, of course, is everything under 85804 must facilitate the national defense, other legal authority deemed to be lacking or inadequate. We've talked about that already. Does not obligate the government to an amount. This actually should read over 34 million without congressional approval, but there's a big footnote on that one. That limitation does not apply if we're talking about an upfront indemnity. All right, so one of the issues that often comes up under 85804 at the beginning of a contract is that the contractor is saying, I'm being asked to do something ultra hazardous, ultra dangerous, in a dangerous place. I'm going to need indemnification. In that kind of a situation, if you have an agreement on an indemnification clause pursuant to 85804, it is not subject to that $34 million cap without congressional approval. That's a big deal potentially. Full and open competition for contract award is still required. Even under 85804, it's not a get out of jail free card on full and open competition. If you want to make the argument that the government should rely on, a sole source justification, you're going to have to go through the normal process of, the government would have to go through the normal process of justifying and approving a sole source procurement. It will not be able to rely on its 85804 authority to get around the competition requirements. Okay, no amendment or modification unless the contract. Next limitation on Public Law 85804 authority: no amendment or modification unless the contractor submits a request before all obligations under the contract have been discharged. So if you're going to want to rely on 85804, going to the government asking for additional relief, it has to be done before before the contract is over. Additional limitations will apply to use of authority by persons below the level of deputy assistant agency head. So the further you go, again, it's common in government contracts. People higher up in the government, there's fewer restrictions on what they can do. The lower down you get, there could be more restrictions. If we go to the next slide, please. All right, different types of contract adjustment. These are the different kinds of actions that you can get. One is an amendment without consideration. So, normally, this goes back to, this question of other legal authority. Normally, in order for, there to be an amendment, a binding modification to a contract, they're subject to the normal rule that there has to be consideration that runs in both directions. If the government's going to give you something, the government has to get something in exchange. That's the normal rule. Here, if let's say there is not consideration, it would just be the government giving the contractor relief without the government getting something in return. that is authorized under 85804. These amendments without consideration require, one, contractor performance to be essential to the national defense, requires a loss. So there has, okay, so it was required, essential to the national defense. A loss has to have occurred, and the loss has to impair the contractor's productive ability. All right, and this also may be appropriate. Well, I'll get to that in a minute. So there has to be a loss, and the loss has to impair the contractor's productive ability. So presumably this would be, so again, the facts here would be, this is a loss that flows from something other than a change. The contractor just had to keep performing, and it is sustained. There's no question, let's assume here, there's no question this was not a change to the scope of work. It was something that was within scope, but the contractor still experienced a, let's say a massive loss. Well, and if the government, if that loss impairs the contractor's productive ability, they can go to the government and ask for relief pursuant to 85804, even though otherwise, under the normal government contracting rules, they would not be entitled to it. This may also be appropriate when a government action unfairly interferes with contractor performance, resulting in actual loss. That would be a situation when there may be an argument. Would you also have a legal theory under the normal rules that you should be entitled to recover? That would be an area where you might be able to pursue both a remedy, a normal remedy, and also an extraordinary remedy. So we've talked about first type of action you can get, extraordinary contract action under subpart 50.1, is an amendment without consideration. Second would be the correction of mistakes. Say there's a mistake in the contract. It says it's, say the contract on its face, requires you to perform work that, your view is it shouldn't have been in the contract, and it was a mistake that it's there. This would allow the government to correct that mistake in the contract without consideration. You don't have to pay the government anything to correct the mistake. The government can correct the contract pursuant to its 85804 authority. And then also formalizing informal commitments to permit payment to persons who have taken action without a formal contract. So this, especially in a war zone, oftentimes, having done a lot of work that came out of the Iraq War, it wasn't always the case that, all of the, protocols of, conducting a procurement and filling out the paperwork the right way, that didn't always happen. Not very surprising that in a war zone, sometimes that doesn't always happen. But yet informal commitments were made to pay, this could come up. Let's say it wasn't even as many of you, as I'm sure know, the normal rule in government contracting is the government is only bound by acts of its agents acting with actual authority. And that 9 times out of 10, if not 10 times out of 10, is going to be the authorized contracting officer, nobody else. And so, but if you're a soldier in the field and you have you need to, let's say you need to rent a vehicle while you're in theater, and you don't have a warrant, and but oh yes, the government will pay. Your government will pay. And then the rental car company says, well, look, we helped this soldier out, who we thought that we get paid. 85804, even though that soldier didn't have a warrant, even though the normal rules weren't followed, 85804 would allow the government to formalize an informal commitment and to permit payment to that person who has taken action without a formal contract. Again, that's not typically would not be the way it would work in a government contract. If you haven't gone through the formal process, you're out of luck. But under 85804, the government can be, come after the fact and formalize those informal commitments. If we could go to the next slide, please. All right, so how does this process work? There's a request for contract adjustment. The contractor submits such a request. Typically, it's a letter to the contracting officer and includes the following information. What is the adjustment you're requesting? Are you requesting an amendment without consideration? Are you requesting correction of a mistake? Are you asking for a formalization of an informal commitment? What are the essential facts? Put together the story. Why is it you're, quote unquote, entitled to the extraordinary relief? Explain what the basis for your conclusions as to why you believe an adjustment is warranted, And you also you should address whether all contract obligations have been discharged and the status of any final payments. And again, as I mentioned before, these requests need to go in before the contract is over, before the government, before all the obligations have been fulfilled. If you're seeking an adjustment above the simplified acquisition threshold, the contractor needs to certify that the request is made in good faith and that all supporting information is accurate and complete. So you're going to want to be careful. Remember, these are representations being made to the United States government. You're going to want to be careful in them. Contracting officer may request additional information, including evidence supporting the contractor's essentiality to the national defense. If again, this all ties back. This authority is dependent upon showing that it's essential to the activity that was engaged in was essential to the national defense. And the government, my example earlier of the soldier renting the car in theater, well, how essential was that? Was that really needed? Why was the car being rented? There might be, there could be questions that the government has along those lines. All right, if we go to the next slide, please. So what then does the government do with these requests? The government, the disposition, when approving or denying a contractor's adjustment request, the approving authority will sign a memorandum of decision. So this is kind of like a final decision containing contractor info, description of the supplies and services, a decision reached and associated costs, the justification for the decision, and a statement that the authorized action will facilitate the national defense. So that's, you can expect a formal decision on your request. The contract requirements, any contract entered into, amended, or modified pursuant to Subpart 50.1 shall contain a citation to the public law and to the Executive Order 10789 that implements it, statement of the circumstances justifying the action, and a recital of the finding that the action will facilitate the national defense. So this would go into, if you're in a situation where you've performed your contract, you've asked for, let's say you've asked for additional relief, additional compensation without consideration, these formalities, a citation to the public law, to the executive order, statement of the circumstances, a recital of the finding, those would go into the modification to your contract. Those citations, those items would be required to be included in that mod. All right, so we've talked so far with respect to Public Law 85804 about the request for extraordinary relief, amendments without consideration, correcting mistakes, formalizing informal commitments. Next, if we go to the next slide, please. Next, we're going to talk about a different strand of 85804 that empowers the president to authorize federal agencies to indemnify contractors for unusually hazardous or nuclear risks that may arise during the performance of a government contract. This also is covered in Subpart 50.1. And this covers, if you turn to your FAR, you will see the special procedures for unusually hazardous nuclear risks are set forth in 50.104-3. And this indemnification under Public Law 85804 is generally available if the contractor's work will involve unusually hazardous or nuclear risks for which insurance is too expensive or unavailable, and when granted such indemnity would facilitate the national defense. And so this type of indemnity is limited. And the question often arises, what is an unusually hazardous risk? Well, the cases I've worked on in the past, if you're performing work, in theater in an active war zone, that's unusually hazardous. And note that it's in the disjunctive, unusually hazardous or nuclear risk. The risk does not have to be related to the use of nuclear weapons. It is broader than that. The indemnification that's available covers a broad range of claims, including third-party lawsuits for death, personal injury, or property damage, or alleging contractor negligence, wrongful acts, omissions, and even willful misconduct or lack of good faith. So where these indemnities become important, say again, you are a contractor operating in a war zone and people get hurt and you get sued. And if you have Public Law 85-804 indemnity in your contract, that means that the government will cover that liability in the event that you are sued, even if the suit involves, allegations of negligence, wrongful acts, omissions, or even willful misconduct. All right, if we could, and also note, note here before we move to that next one, also note, that one of the requirements here is that the contractor's work will involve unusually hazardous or nuclear risk for which insurance is too expensive or unavailable. So there is still an expectation, that you would try to get insurance. So if this only kicks in, again, remember, everything we're talking about here are extraordinary contract actions outside of the normal. So if insurance will cover the liability, this is not going to be available. So there would have to be a demonstration there is no insurance that will cover this risk. And also, as I noted before, this is why I noted it earlier, this Public Law 85-804 indemnity is not subject to that $34 million cap. So all of those other, when we're talking about the amendments without consideration, et cetera, correction of mistakes, those were subject to the $34 million cap, or you got to go tell Congress. This is not subject to that cap. And so normally in government contracts, when we talk about indemnities, that everybody, kind of can cite chapter and verse. Under a government contract, the government is not authorized to enter into an open-ended indemnity. And this is the exception to that rule. These indemnities are open-ended. So it's even with, if you're familiar with the normal rule, under what's called the Anti-Deficiency Act, the government cannot enter into obligations in excess of appropriations. So normally the rule is when the government's entering into a contract, it has to have the money to cover that contract at the time it's entering into it. That's a simplification, but that's the general thought. Here, the government's entering into a contract that has this potentially, wide open liability indemnification provision in it. Who knows exactly how big the liability might be? Public Law 85-804 authorizes the government to enter into such indemnities. Go into the next slide, please. Right, special procedures. Given what I just said, you can understand, I'm sure, that the government wants to be careful before it enters into these kinds of indemnification provisions. So the government, there are special procedures in the section that I mentioned, 50.104-3. Special procedures for unusually hazardous or nuclear risks. And so the contractor will submit a request for the inclusion of the indemnification clause, including a statement of the unusually hazardous risks and how the contractor would be exposed to them. Request should be submitted shortly after contract award, and preferably, of course, from the contractor's perspective, before performance begins, because if you don't have the indemnity, you want to protect yourself so that as you're performing, if something bad happens, you got the indemnity in place. If you go ahead and start performing before you have the indemnification, you're hanging out there a bit. Contracting officer with assistance from legal counsel and the cognizant program office personnel will review the request for indemnity and make a determination. If it's denied, this contracting officer must promptly notify the contractor and provide the rationale. If it's proved, there will be an execution. The CEO will execute a memorandum of decision and will incorporate into the contract FAR 52.250-1. That's a standard FAR clause that addresses indemnity under 85-804. The contractor may, with government approval, then indemnify subcontractors. So this is an indemnity that can flow down through the contracting chain. If we could go to the next slide, please. Again, this is all straight from the FAR 50.104-3. Tribunals generally lack jurisdiction to review agency decisions denying Public Law 85-804 indemnity. So if the government says no, that's generally going to be the end of the discussion. when if you've requested indemnification and the government's turned you down. Public Law 85804 indemnification provisions will be enforced once incorporated into a contract. And then, here's key, the key, what are the keys to securing this indemnification? Think of it, it's persuasion. You got to persuade the government that, one, the contractor is delivering a product or service that is critical to the national defense. Remember, this all kind of relates back to national defense. Two, based on past experience, there is a material chance the contractor could be exposed to significant third-party liability. This can't be simply, oh, I feel nervous about this, please give me an indemnity. Now, there has to be some, basis for it. And three, insurance and other forms of protection are either not available, too expensive, or too limited in coverage. Again, so this ties back to, this showing about the insurance that's available. And you have to show it's either, not available at all, it's too pricey, or it's too limited. All right, so that's, again, if you are engaged in any activity that you think may be unusually hazardous and create, potentially significant third-party liability, you're going to want to carefully think about, asking for indemnification pursuant to Public Law 85804, using these procedures that are set forth in FARS Subpart 50.1. With that, and we're about halfway through to our 1 o'clock end time, we are going to shift gears now. So we've been talking about 85804, extraordinary contract relief, indemnification. Now we're going to shift gears. If we go to the next slide, we're going to shift gears and we're going to talk about the Safety Act. The Safety Act, as I mentioned at the outset, the Safety Act was passed shortly after 9/11, and to incentivize makers or those interested in designing and making anti-terrorism technology, to incentivize them to do so. Again, the concern Congress had in the aftermath of 9/11 was that companies would be frightened to get into the anti-terrorism technology business due to the potential liability to third parties down the road in the event of another terrorist attack. And so the Safety Act was designed, again, to incentivize contractors, to incentivize companies, not just contract, to incentivize companies to get into this line of business. So the Safety Act, you see it's all caps, SAFETY. If you spell it all out, it's the Support Anti-Terrorism by Fostering Effective Technologies Act of 2002. So as I mentioned, it was enacted to encourage development and use of anti-terrorism technology and provide risk management and litigation management for sellers of what's called qualified anti-terrorism technology, QATT. It created liability limitations for claims arising out of, relating to, or resulting from an act of terrorism where QATT, qualified anti-terrorism technology, has been deployed. And also note that we are now talking about FARS Subpart 50.2. Everything we were talking about with 85804 was Subpart 50.1. We are now to 50.2. And what is qualified anti-terrorism technology? It is any technology designed, developed, modified, procured, or sold for the purpose of preventing or deterring acts of terrorism or limiting the harm such acts might otherwise cause. So, for example, screening services, security, detection systems, threat and vulnerability assessment systems. Read it broad. I mean, it can be read very broadly. It can encompass a lot. So, that is potentially, if you're in the government contracting business, it is something to think. Does anything I make, could it be used as an anti-terrorism technology? Could be a very broad definition. If we could go to the next slide, please. All right. So Safety Act scope. The scope is set forth in FAR 50.200. This subpart implements the Safety Act liability protections to promote development and use of the anti-terrorism technologies. The parties covered by these liability protections are referred to as sellers, and they include any person, firm, or other entity that provides a QATT, a qualified anti-terrorism technology, to customers. And the protection, it's important to note, the protection of the Safety Act extends to users. So the claims, to the extent that Safety Act provision is Safety Act liability protection is granted, that extends down, and so that claims may not be brought against the buyers of the QATT, the buyer's contractors, or downstream users of the QATT. So the designation flows with the technology. It's not just for the entity that's selling it. It's that the protection attaches to the actual thing that's being sold, and it flows down through that supply chain, or through that chain. If we go to the next slide, please. There are two levels of liability protection that are available under the Safety Act. One is called designation, and designation, that's the lower level. The designation, and one thing that's important, where you're getting this designation or certification from, you're getting it from the Department of Homeland Security. And so the Department of Homeland Security is going to be the entity that grants either designation level protection or certification protection. And there's an entire application process that DHS has stood up to grant these Safety Act determinations. All right. And again, with your goal being, if you go in and submit your application to DHS for Safety Act coverage, you're either going to hopefully receive either designation or certification level protection. Designation level protection, the seller's liability for products or services that are deemed a designated technology will be limited to the amount of liability insurance that DHS determines the seller has to maintain. And so when you get your when you go through the process with DHS, and if they decide to give you designation level protection, they will assess an amount of liability insurance that they are going to require you to maintain. And there's two different types. They may give this designation level protection in a couple different scenarios. One would be developmental test and evaluation designation. That is for technology that is in prototype stage and shows potential, but more evidence of effectiveness is still needed. That's one level. Then the next level up is full designation. So that is for technology with proven effectiveness. So as you can imagine, it is easier to get, as you go up, if the higher you go up here. So actually, when you're looking at designation, there's even two levels within designation. One is the developmental test and evaluation designation. That's kind of when you're still in product development. You're still able to get some level of protection. Full designation for technology with proven effectiveness, you can expect that for the developmental test and evaluation designation, you could expect that that insurance you're going to need to maintain will be at a higher level than if you get full designation. Because again, at the developmental test and evaluation stage, you don't have complete evidence of effectiveness. At full designation stage, you do have proven effectiveness. So, as DHS is assessing that will be taken into consideration, in determining what is that level of insurance that you need to maintain. And then that level of insurance will be your cap. All right, so that's designation. Well, what if you get certification? That's the higher level of protection. That provides the designation protections, all right? So, liability capped at the level of insurance, but it also allows the seller to assert the government contractor defense for claims that arise from acts of terrorism. All right, now the government contractor defense is a common law, had been developed through the common law of government contracts years ago. The State Safety Act codified it and put it into the statute book for designated for designated anti-terrorism technologies. And what the government contractor defense allows a contractor to do if they are sued. All right, so the fact pattern here would be you are a maker of qualified technology, you have it listed, you've gotten certification for the product or service through DHS, then there's a terrorist act. People get hurt, people are maybe even killed. You are sued in tort. So you're in a tort suit somewhere in the country. You would then, if you have received the certification level protection from DHS, you would then have a basis to move to dismiss the lawsuit. And the basis, and so the government contractor defense, which as I said goes back a long time, goes something like this. We make a product according to a government approved spec. And the government is generally, normally the government is immune from suit, and this kind of protection is a bit of a is kind of related to the government's general immunity from lawsuits. So this, here you would be saying we made something exactly how, in this case, exactly how we told the government we were going to make it. And since we followed this government approved spec and we are on the certification list of DHS, we are immune from suit. And so this gives the entity here who makes the qualified anti-terrorism technology that has received the certification level of liability protection, it gives them a basis to try to get out of a lawsuit early. So, as opposed to what would normally happen, which is then, there'd be a claim of negligence. You didn't make the technology correctly, and that led to the injury, that led to the death. And so then you fight in the lawsuit for a long time. You potentially have a jury trial, all of that kind of stuff. The government contractor defense is aimed at enabling makers of these technologies to get out of a lawsuit sooner rather than later. Again, this goes back to the whole purpose of the Safety Act, which is to incentivize folks to get to design and make these technologies without the concern that if they get sued, they're going to have to be in a litigation for a long and extended period of time. That is part of the policy behind the Safety Act. All right, so that's a big deal, and that is a big difference between with just designation level, you're not getting that kind of immunity from suit, and that's kind of like the gold standard of what you're looking for if you go into DHS to try to get Safety Act coverage. And then 3, we've talked about the government contractor defense. 3, the certified technology is placed on the Safety Act's approved product list for Homeland Security, which again, that has a marketing benefit to you. So if you have, you're on the approved list, you can say, hey, we're on the approved list of anti-terrorism technologies for Homeland Security purposes, and that also has of course a benefit to you as a maker of qualified anti-terrorism technology. All right, if we could go to the next slide, please. And this is just a little bit of a summary of the different levels of protection. So, as you go from left to right, the protection gets more significant. So as we talked about, at the lowest level of protection is your developmental and test designation. And then, as you look across the chart, this first substantive row, effectiveness evaluation. So at the developmental and test designation level, the effectiveness evaluation, you're going to need, the product is still in development. You're going to need more proof, but there is a potential that that the technology will be effective. All right. And if that's where you're at, and that's all that you can demonstrate because you're still in the developmental stage, there is a liability cap, but only for identified test events. Again, so you're in you're in the developmental and test phase. So the liability cap is only for identified test events and for a limited duration. So that's less than 3 years. So if you go in and DHS gives you developmental and test designation, that's going to cover you through the test period for test events. It's not going to cover actual deployment of your technology. All right, but still, you may want to, so it's limited and it's only up to 3 years. However, the testing of this equipment itself could be dangerous, and if you want to have some level of liability, capped liability, if you want to cap your liability even for the testing phase, this level is available to you. You go from that up to full designation. That's proven effectiveness with confidence of repeatability. All right, so it's certainly a step up from development and test. If you get the full designation, you get that liability cap we've talked about, and it's for any and all deployments made within 5 years. So it lasts, your Safety Act full designation has a 5-year shelf life, at which point then you would have to do a renewal application. All right, so every 5 years, you'd have to go back to the extent that your technology itself has a longer useful life than 5 years. You'd have to go back. So that's full designation. So proven effectiveness with confidence of repeatability. And then you go up to certification, the highest level of protection. That is consistently proven effectiveness with high confidence of enduring effectiveness. So you see, that's the big distinction between full designation and certification, is the level of effectiveness, how often it's been proven, and how high your confidence is in the continuing effectiveness. Those are the differences. So the higher up you are, the better you can make that case of full confidence, that the better your chances of getting certification. All right. And so if you get that, you get the government contractor defense as well as the liability cap for any and all deployments made within 5 years. So again, gold standard, that's your ultimate coverage under the Safety Act, would be getting the certification. But again, like full designation, it's for 5 years, and then you'd have to reapply. All right, if we go to the next slide, please. All right, so what are the Safety Act criteria for designation? All right, so again, this is just putting a little more meat on the bones of what we've already covered, but prior government use or demonstrated substantial utility and effectiveness, of course, that is helpful. I mean, if you can show the government itself has used has used this, or otherwise you can demonstrate substantial utility and effectiveness, that is part of the criteria. Availability of the technology for immediate deployment. So again, especially if you're looking at, full designation or certification. If you're looking at full designation, of course, it's got to be, out of development and test. There has to be the existence of extraordinary large or unquantifiable potential third-party liability risk, exposure to the seller and the users. So what's the purpose for this? DHS doesn't want to waste its time evaluating a technology where there isn't much, there is no substantial or real chance of an extraordinarily large or unquantifiable potential third-party liability risk. So you're going to have to make, in your application, you're going to have to make the case, look, we need this protection because of this massive potential liability out there that is, if our technology doesn't work, we could potentially be subject to. There has to be substantial likelihood that the technology would not be deployed unless the Safety Act protection was granted. So, if you're, again, this is to incentivize kind of cutting edge technology. If you would be doing this activity anyway, even if you didn't have the Safety Act coverage, that decreases the ability to show that you're really being incentivized and you really need the protection. Evaluation of scientific studies that can be feasibly, and then the last here, evaluation of scientific studies that can be feasibly conducted to assess the capability of the technology to substantially reduce the risks of harm. So you have to also, the government will evaluate, if there have been scientific studies that can feasibly be conducted, can we make this technology safer? are there to reduce the risks of harm, because again, the government doesn't want the Safety Act used just kind of carte blanche to be, as a doesn't want companies to view the Safety Act as a reason to, cut corners or to not make their technology as reasonably safe as possible. So that's what the last criterion there is aimed at. And then beyond designation, if you're looking at the Safety Act criteria for certification, you have all of those designation criteria that we just talked about, plus the qualified anti-terrorism technology must be shown to, 1, perform as intended, 2, conform to the seller's specs, and 3, be safe for use as intended. So again, to get the highest level of protection, you have to go beyond these first 5 criteria we were just talking about, and also demonstrate, look, we make this thing in accordance with our spec, it performs as we intend it to perform, and it is safe for use as it's intended to perform. So again, it's so the chance that that all helps to reduce the chance that if something does happen, that the government doesn't want to be insuring or giving out government contractor defense to technologies that don't work. That's not in the government's interest, or to technologies that don't conform to the spec. That doesn't make any sense. So to get that highest level, the government wants kind of some quality control around the technology that is going to give that highest level of certification to. All right, if we could go to the next slide, and we just have a couple of slides left. All right, there are, of course, the policy behind this, as stated in FAR 50.204, agencies are encouraged to encourage offerors to seek protections for their offered technologies, even in advance of the issuance of a solicitation. So if the government is purchasing a potential anti-terrorism technology, the agencies are encouraged, hey, and they're putting out a solicitation, they are to encourage offerors, hey, go talk to DHS, even in advance of issuing a solicitation. Hey, we're thinking about purchasing anti-terrorism technology. We're interested in your technology, but it's not covered by the state. You don't have Safety Act coverage. Why don't you go talk to them? The agencies are encouraged to do that. Again, that makes it, the government, kind of DHS, think of it as like a good housekeeping seal of approval as well. For you to be able to come into an agency and say, yes, we're on the approved list for DHS. That makes the agency's job easier as well. And the DHS determination to extend Safety Act protections for a technology is not a determination that the technology meets or fails to meet solicitation requirements. So it's important to keep that in mind. It's 2 different things here. DHS is not looking at whether your specific technology meets a specific government requirement. That's not what they're doing. DHS is looking at, is it something that meets the criteria for Safety Act coverage? Does it, as we were looking at on the last slide, it's a broader type of look. But that does not mean that your technology is going to necessarily meet a specific government solicitation. So again, those are two different things. Procedure considerations 50.205-1, requiring activities should review requirements to identify potential technologies that may be appropriate for Safety Act protections. So again, this is what we were, goes hand in hand with the agency encouraging offerors to seek Safety Act protection. So if you're with the government, your requiring activity, you should look at your requirements, and I go ahead and identify, are these technologies that we're considering, would they be appropriate for Safety Act protection? And if so, then you would want to encourage offerors to go get the protection. And then acquisition officials should consider Safety Act issues early in the acquisition cycle, which again, of course, whether, if you're purchasing, this will all start with an assessment. Are we purchasing something that's arguably an anti-terrorism product or service? If we are, how does that affect the acquisition? Do we need, how does that affect our requirement? How does that affect our outreach to potential offerors? All of that, should be taken into account early in the acquisition cycle, not at the end, because you can understand that if you don't start thinking about this stuff early, but we're about ready to issue an award, but hey, doesn't the Safety Act have some potential relevance here? It could kind of unwind everything you've done, and you don't want to be in that, the government doesn't want to be in that position. Next slide, please. Okay. And this also goes along with, as an agency is considering its needs, FAR 50.205-2, if the required activity determines the technology to be acquired may qualify for Safety Act protection, the agency is responsible for requesting a pre-qualification designation from DHS. So DHS will determine whether the technology affirmatively or presumptively satisfies the criteria for Safety Act protection, and will authorize offerors to submit streamlined applications for protection. So again, this goes back to the agency. The agency needs to make this assessment, and if they do, and they reach out to DHS for a pre-qualification designation, that could speed the process up for offerors. Again, that's going to be a function of the government-specific requirements in that specific procurement. Authorization, the FAR does authorize offers contingent upon Safety Act protection, and it also authorizes awards made presuming Safety Act protection. So, this addresses, that we only going to, this offer is contingent upon us getting Safety Act protection. That is authorized, and also authorizes the awards that are made presuming that you will get the Safety Act protection. Both of those things are authorized under the FAR. So, the Safety Act is a powerful tool in a number of ways. The Safety Act can help a contractor who, and again, as I said at the beginning of this section, think broadly about what could possibly be anti-terrorism technology. It's a potentially very broad universe. If you arguably have such a technology, Safety Act is a powerful tool to insulate yourself or better protect yourself from third-party liability. And as I also mentioned throughout this section, it's also a way, as you're working with agencies, again, it's that good housekeeping seal of approval. It'll make the government's job easier potentially if you can say, hey, we're approved, we have Safety Act coverage, again, kind of already blessed by DHS, even though just having DHS, just having Safety Act coverage does not necessarily mean that you're going to necessarily meet the spec of a particular government requirement. You're still going to have to jump through all of those regular hoops that you're used to. All right, so we're reaching the 1 o'clock hour. If we could go ahead and go to the next slide, you'll see a picture of my colleague, Mr. Surya. He and I, on his behalf, thank you for participating today. I hope that this has been a productive session for everybody as we've talked through, these extraordinary government's extraordinary authority under FAR Part 50. And if there are any questions following, Alex's contact information is here. My contact information is remarkably similar. It's jworkmaster, JWORKMASTER @milchev, MILCHEV.com, and my direct dial 202-626-5893. I'd be happy to take any follow-up questions or calls you may have. And thank you so much for your attention. And I hope everybody has a great rest of your day.
Thanks for a great presentation, Jason. And to our audience members, we thank you again for participating with us. And if you have any questions about federal contracting or need assistance with any of our services, please contact us directly. Thank you again for joining us. And this concludes today's webinar.